Welcome to another episode of Wakili Quick One. We are on season 3 of this mentorship stroke historical documentation of series. And this year, this is our first episode, and there's no better person to start our year than the one and only Chief Justice Emeritus, Dr. Willy Mutunga. Hi.
Hi.
How are you?
Great.
Karibu sana.
Asante.
Yes.
Yeah.
Now, I want us to go straight into it.
Mm-hmm.
Where does...
So, are we looking at the camera?
Yes.
Oh, okay. Yeah. Sorry.
So where does the younger Willy Mutunga grow up? Where were you born?
Mm-hmm.
Where were your formative years? Where do you go to primary school?
Yeah.
Yes. I want to trace that small journey.
Yeah. So I was born in Kitui County. My village actually is called Kilonzo. It's very close to the town.
Yeah.
And I went to school, primary school then, they were called Kalawa Primary School, which was also pretty close. It was one of the village schools, but Kalawa was very close to Kitui town. And that's where I did my 4 years of primary schooling. Then I went to Izokwe intermediate school. There was primary school, intermediate school, and then secondary. And so I went there. That was, I think, 58 to 61. Then I joined Kitui Secondary School, 62 to 65. Then Strathmore College of Arts and Sciences. That was 66, January 68. And then I went to the law school, University of Dar-es-Salaam, 68 to 71. Came back to Kenya, did my bar exams. I was admitted to the role of advocate on the 19th of June 1972. Then I went to Kitui. I was employed there by a firm of Kakuli and Mati advocates. And I practiced there for about a year. And then went to do my master's in Dar, which I finished in 74. So came back to Kenya and got a job as a lecturer in the University of Nairobi. And I was practicing, but what we call pro bono. I joined Kituo Cha Sheria as one of the volunteer lawyers. And I also represented quite a number of university students because they would go and fight in bars and they would be charged to do all manner of things. So it was part of the pro bono work that I was doing then. And the university was, I loved teaching, but that came to an end with my detention in 1982. And I was fired from the university. So when I was released in October 1983, I quickly applied for a practicing certificate, which Mutula Kilonzo Senior processed very quickly. He was the chair. I will never forget his solidarity, because he realized I didn't have a job, and so I got my practicing certificate. So I worked from Zioka and Company advocates, while doing my own criminal litigation. I did some pretty good work in the defending bank robbers. Some word I met in prison, and that's from 84. By the time we get to 89, all my clients had been killed. By them.
Let me put that thought there.
Yeah.
Let me take you. Let me take you back briefly.
Yeah, sure.
And this is a moment I want you to correct. to correct a few things that are wrong on Wikipedia. One, it says that you did your undergraduate at the University of Nairobi, then you proceeded to University of Dar.
Yeah, that's wrong.
That is wrong.
The Faculty of Law in Nairobi didn't exist when I went to Dar.
At that time?
No. Because it started, I think, 73 or 72.
Yes.
And it was a class from Kenya School of Law.
Yes.
That was taken there.
Yeah.
People like Lady Justice Olwoch.
Olwoch, yes.
It was that class that was taken to the faculty now to start their education, legal education. Yeah.
Okay. So also your detention. There's always the argument that you got detained because of the 1982 abortive coup.
No. No, the coup happened when I was already in detention.
Yeah.
I was detained on the 29th of July.
Also a few days before the coup.
Yeah. Because before detention, I was charged with sedition. Okay, so when I was arrested on the 10th of June 1982, I was then charged on the 12th of June with, they said with sedition. And the facts were that I had in my possession a seditious leaflet titled "Reject These Nyayos, JM Solidarity." Okay, but they didn't prosecute. At sometime in July, they decided that they were going to detain me, and so the withdrawal, that case was done when I was already in detention. In fact, I doubt whether we knew about I didn't know about the coup d'etat until I came out.
So by the time you're getting in, the coup has not happened.
Yeah, because it happened 29th, and I was detained on the 29th. On the 30th, I was flown to Mombasa. Okay.
Yeah.
So when it happens on the 1st, we were detainees.
Yeah.
Maybe the only person who probably must have known is Koigwa Mwere.
Or you with Koigi at that time?
Yeah, he was detained later.
Or later on.
Yeah, although the Gazette notice on 6th of August was about me and him.
Yeah.
Yeah, but he was he must have been in custody.
Yeah.
At some point. So there was no connection. The reason I was detained was because of the activism in the university. I was the Secretary General of the University Staff Union. And one of the things we were really, really serious about was academic freedom. Because it was violated completely. There was a time when all radical books were removed from the bookshop and the library. There was, when you talk to a lot of students who were students in the 70s, they would tell you that the police would come and sit in those classes, to intimidate, lecturers and so forth. So it wasn't a good environment, and we stood up against it. The university then was the only site of struggle. Women's movement joined KANU, the unions, so it was a very clean dictatorship at that last point. That is at the university where the students and the lecturers stood up and said, no, we fight for academic freedom. Nobody tells us what we should read and what we should teach. There is a curriculum, and that's what we are going to, to follow. And then we had, as usual, mass action, like when Rodney was killed in June 1980. we had a big demonstration because it was what Rodney was known in all universities. He wrote that book, How Europe Underdeveloped Africa. Yeah, and he was my professor in Dar, although he wasn't teaching law, but so I knew him. So that was the student activism start, and the fact that the university was the only site of struggle. The others had been silenced, and that's why then the detentions happened. And of course, when the coup happened, students joined, people like Tito Adugosi, and there were, jailings and detentions of, students, during that period. And that's when they also got involved with the Mwakenya, which was another organization. Yeah.
So now that you've corrected that narrative,
Yeah.
you also say that all your clients by the time you're coming back were dead. Was it deliberate? Or
They died before I went to study.
Or do you think it was deliberate?
It was deliberate. It was extrajudicial killings. Have you heard of the guy called Patrick Shaw?
Yes.
During that particular period, a lot of the bank robbers obviously were known, but a lot of them, like the ones I represented, a lot of them kept on being released because I used to challenge the confessions and get them off. And so I get them off on Friday. On Monday morning, their wives come and tell me the guy he's been arrested. Because the moment they would get out of prison, they are planned. I don't know how they plan those robberies. They go and hit somebody else almost immediately. And I interacted with them, very brilliant, young men and women. There's the last case I handled was the robbery of 2.8 million from the National Bank. And there were two women who are actually the masterminds of that robbery. One was called Mama Kariko, the other one was called Mama Isli. Very, very, very brilliant people. They planned it, and then got they recruited the criminals who are going to do the work, and they took 6 months to plan that robbery, and it was simple because at Tusker, that's where the Kenya Brewery said go down, and over the weekends, because banks were not opening over the weekends, robberies used to take place on Monday as they move the money. So they will get hit all the time. But because this one was fairly big and it was in town, it wasn't outside and so forth. So they planned it. There was a matatu driver who was fantastic, who drove the getaway car. Then the thing that these women did, which was crazy, but very admirable, they got a guy called Superintendent Kibuya from Kitui, who was in charge of the 9-9. So when the robbery happened, this guy was saying that the thugs are headed towards Thika when they were headed towards
Nairobi.
Karen. They got to where they were going, and they shared the loot, and they took off. But Shaw knew them. He knew exactly who these people were, because every intelligence system or criminal justice, criminal investigation department has suspects. And the Shaw was very sure who they were. And so he arrested them. the case. They were acquitted. I was in that case with S.M. Otieno and Hamino. Yeah. In fact, Hamino was at his best when he was examining Shaw, in what is called trial within a trial, because we challenge the confession and so forth. And there was one accused person who was not tortured. The women were basically tortured. They could show that there was torture, but there were some guys who are not tortured. But when they were arrested, they were taken to the police station, and then Shaw came there, and he didn't say anything, and he was huge, and so Kaminwa cross-examines him, flatters him. People call you a crime buster, yes. You are actually, huge. And they said yes, and you will be known to deport, criminals from Nairobi, and when they come back, you kill them. She is British, and they are not supposed to tell lies. Says, yes. And, you were feared by criminals in this part of town. And he said, yes. So he was asked the killer question. When you went to that place where these guys were recording their confessions, do you think they were free? And he said, no.
Finished.
Finished. I thought that was a brilliant cross-examination, because it's not always physical. It can be psychological. And that guy had a reputation. It's like a guy who kills people and uses his gun, and he comes to the room where you're being interrogated. Of course. Yeah. Or he puts it.
Yeah.
Yeah. So then I started seeing, the pictures of these guys in the papers. And at that point, I said, hey, this is my only criminal practice. They might, after all, come after me.
Yeah.
Let me go and read. Yeah.
So that's when you go and you finish your PhD.
Yes, I go to Osgoode Hall Law School in Toronto, and I, do 3 years there, and then come to do research in '91 when then Moite and Mother Karua and others and GBM Kariuki, Charles Nyachai, Mbai, a guy called Juma, we joined, the LSK, council. Yeah.
When you're having a conversation here, you told me how elections were being done at LSK at that level was slightly different from how we do them now.
Yes.
Maybe just so that our young audience can understand how elections were conducted during those days.
Yeah. Well, as I said, the bar was small. A lot of people were practicing in, major towns. I know, like in Kitui, there were only, when I went there in '72, there was only one legal firm. Two. There was another one. There were only two. So Nairobi had the majority. But the convention was that you don't campaign. You get people to nominate you, and that's it. People vote. No collecting of, voting envelopes and taking to wherever. And obviously, the whole question of campaigning or even bribing people wasn't accepted. And there was a convention that if you won, you were not opposed, the second year, because it was ultimately 2 years, and that's it. Yeah, so it was based on what the bar felt they needed, because the LSK has always been political, whether it's conservative politics or radical politics. So if the situation with the political establishment required fiery people, the bar would, basically vote them in. And there were always issues, because I remember I was telling you, people like Mutunga and Wako dealt with Africanizing the bench, but also trying to say that the entire practice was in the hands of whites and brown people, and that the Africans, didn't get much of business. And this is being said within the national politics of Africanization, right? Because after independence, that was a big thing. Yeah, so the voting was, there were conventions, and there was no, corruption. The bar realized at some point, I think in 1972, that they must have an African president. And the first African president was Sam Waruyu. Okay? And then after that, there had been whites and Asians, and then now the Africans started, taking over in 72. So the bar was responsive to the politics and so forth. And that's how, as I was telling you, people like Wako, Ojambo, and others now join the white firms, as partners. It's a way of
Africanization.
yes. so it's the whole question of corruption, comes much later, and it's despicable. Yeah.
And when these black lawyers are joining the Mzungu law firms, I remember Paul Mwangi in his book, The Black Bar.
Oh yes,
he calls them letterhead partner.
That's the politics of it, of Africanization.
Yes.
I mean, even at the political level, those who ran the government were also letterhead leaders. The colonialism was still entrenched. But I think the white firms did the right thing. They realized this was an issue. And you cannot just have these guys running to court and doing, the heavy lifting, that you don't make them, partners. But I think that's how they started. The development that Mwangi should have also discussed is that they actually ended up owning those farms. Okay? Yeah. Harrison and Matthews now is different people. Kaplan and Stoughton is Ojambo. So the white aspect of it is not there anymore. Yeah.
But if I may ask here,
yeah.
How comes those firms are still dominating the market?
Well, because of their history. Yeah, their major clientele is multinationals and banks, which are still the mainstay of the financial sector. And there is a very rich white community in this country. It's farmers, it's in finance, it's in insurance. So it's still racialized. You can actually say that. Yeah.
So now let's continue the journey.
Yeah.
So you come and you join the LSK.
Yeah.
How does that go?
As president?
Yes, I want your entire tenure, either as president, you serving the council.
Yeah. I actually didn't serve. Wait a minute. I served as a council member. And I knew I was going to be elected because I taught these lawyers. Yeah, and what happens with the teachers is I still think I was a very popular law lecturer. So there might have been few people who didn't like me, but I knew if I applied to, if I was nominated to be a member of the council, I'll get in. And I got in. This was 82 actually, the year that, no, 81. So I served, I think, a year, and then the second year, I was out of it. And who was the chair that I can't remember what was our chair when I was council. Is it maybe Muthoga? I'm not sure.
Okay.
Yeah, maybe Muthoga or somebody.
Kilonzo
later.
Oh, yes.
Because Kilonzo, I find him in 83 when I get out of detention. So there was I can't remember who the president was that time when I joined, but it was a short-lived experience because I get into trouble and out of it. Then in 91, with this second liberation, I was approached actually by Mother Karua, who came and told me this is the team of people who we want in the in the council, because the council has to do some political work, and you have to run for vice. I said, okay, fine. I joined the trenches again. So, and the Moita was there. He threw us into the deepest end, because when he gave his speech, he he told the government to register Jaramogi's party. So you've heard that story where judges, when he said that judges, who are invited, just, trekked out of there, it must have been Intercontinental. It's only one judge called Shields, Frank Shields, who was very radical and very popular. He didn't move. He Irish, he enjoyed his beer, he stayed put. So, during that time, the second liberation, there's a lot of stuff about what happened to that council. Because we were prosecuted. Muita made a statement and we supported it. So the famous case that was filed by Nazi Barasa, somebody, who was the other one? Ringera. There was another guy, there's a Luo guy. There were 4 people who basically went to court and said that the Law Society should not play politics. Okay. And we responded. Then we were charged, we're now charged for disobeying a court order and the contempt. And it's Judge Mwera is the one who finalized it. When it was finalized, actually, I was already out of the country. I was campaigning in the U.S., in the American Bar Association, to help the Kenyan, the LSK. And we were fined, I think 10,000 shillings each for contempt. And so we told the judge that we won't pay. You take us to committee. The judge said very cleverly, Mwera, He said, yeah, this is what you want. You want to be heroes. I will give you. You either pay
Yes.
or we're going to seize your properties. It was so funny, yeah.
Yeah.
Mm.
Did you eventually end up paying for it?
No. The Law Society paid for it. Yeah. They paid for it very quickly. I think we still owe them that money. We never reimbursed it with the interest.
That's ridiculous interest.
Yeah, that will be a lot of it. Yeah.
Yeah.
But that's how I was telling you earlier that Judge Kariuki was president from 1888.
1988.
Yeah, 1988. And he was involved in the Mlolongo elections, and he also fought against the withdrawal of security of tenure of Attorney General. So, and we basically came after, Muite. After Muite, I took over, and then Wamai, and then But the Law Society always has an issue, Every president faces an issue. And
internal or external?
Internal and external, yes. And you have to deal with it. Faith, our president, is dealing with abductions, extrajudicial killings, kidnappings, and disappearances, and so forth. That's our niche. Yeah.
And so let me ask a question around that.
Mm-hmm.
Perhaps maybe I'll distract you from your thought, but you can come back again.
Just come back.
Yeah. So as you've rightfully said, Faith is struggling with issues that have been in our country and have affected you like decades back.
Yeah.
But we are now dealing with a new constitution. So perhaps you can talk about your journey of seeing abductions through all that period.
Mm-hmm.
And I hope you had maybe with a new constitution
Mm-hmm.
and your sentiments on where we are now.
Yeah, actually, it's ironic that the Moi dictatorship, the Jomo Kenyatta dictatorship, didn't disappear people. Okay, there were extrajudicial killings of criminals, but the political, the people who are charged with, either sedition or whatever, they followed the law. Okay, you'll be taken to court. If you're detained, of course, there was the public security, the preservation of Public Security Act.
Yeah.
So it will be legal, and you will be gazetted, and every 6 months you appear before a tribunal for people to know that you are alive and so forth. So there was a bit of law and order, and there were cases where some people, of course, were disappeared. For example, the case of the guy called Karanja, where he disappeared. He was arrested and disappeared, and of course killed by the police. And they went to Judge Schofield. Judge Schofield said, "You have to, to get that body." So I guess the executive ordered Judge Miller, CJ Miller, and a lot of those CJs were just appendages of the executive completely. So he took over the file and said that you can only produce somebody who is alive. if they are dead. That's why the agencies are saying produce so and so, dead or alive.
Yes.
It's because of that jurisprudence. And that's how this Judge Schofield became a hero. Even in his own country, he ended up being the Chief Justice of Gibraltar, and he went to the Caribbean. He was famous for that, courage. So there were a few bits. There were political assassinations that we know, whether it's Boya, whether it's JM, Kariuki, whether it's Pio Gama Pinto. People suspect Kodek was also a victim of political assassination. So that happened within the politics. But for the ordinary people, it's the criminals who actually, they started, as I said, killing in the 80s. They will be taken through the legal system, and a lot of them were actually jailed because they will probably not be represented and so forth. So the irony is that it's the constitution that is so progressive and that has provisions that was supposed to stop this thing, extrajudicial killings, respect of rights. If people demonstrate it under Article 37, they have to be peaceful and unarmed, And actually that article commands the police to protect them, to protect that right of demonstration. And the idea when it was discussed during the constitution making process was that demonstrations can be can resort to a breach of the peace, particularly if one demonstration is being stopped by another one, because that is for politicians having their own demos, and then people want to stop to stop them. So the police are supposed just to make sure that it's peaceful. That's how also you get the provisions in the constitution about bail for treason and murder. And that is informed by that history, like Raila, for example, who was charged with treason after the coup, didn't get bail. Murders, no bail. So that has changed, because the presumption that you are innocent until proven guilty, and you can just be free. And so it's so when you look at what the police are doing, what I see is a colonial police force that still dominates, the country. Maybe the colonial guys use the law invariably to charge people and so forth. Even Kimathi was taken through the judicial system. But at some point, the extrajudicial killings, the politicians being assassinated up to Kina Okong and so forth. This is a history that informed, the provisions in the Constitution. So that status quo is, history. Yeah. But as they say, the Constitution, we gave birth to a beautiful baby. We called the 2010 Constitution, but we gave it to the child traffickers. So we shouldn't be complaining. Yeah. Ask people who are child traffickers to take care of a beautiful baby.
Actually, that should be the title of this episode.
Yeah.
Now, just where were we in the history?
We were
after Canada.
Yeah, that's prior to the second liberation, constitution making, struggles up to 10. And I think he had asked, when you look at that trajectory,
Yes.
Isn't it ironic that, some of these things should be happening, and some of them are very crude, like the one of Brian, that guy in Nakuru. They always say they didn't know, and then his body is found floating like in Nakuru. So that's, in my view, explains the anger of Gen Z and millennials. Okay, and this anger is not going to go away. Yeah, in fact, we should be prepared for an uprising in June.
So let me just a build up towards that.
Mm.
Now that you've mentioned that, in the 80s, you get into trouble because of activism at the university.
Yes.
And the people who were there are students, basically the ages of the Gen Zs that we have now.
Yeah,
And again, it's happening.
Yeah, Gen Z. I'm Gen Z alumni. Everybody is. Yeah.
And the same thing is happening. Does it bring back the memories? Like you went the same thing in the 80s, and now the same thing is happening. And the fact that even removing you from retirement to take you back to the police station to demonstrate.
Yeah, it's the thing about struggle. Any struggle or you are involved in. And in my case, when I came out of detention, because I was innocent, I was detained, and I was very bitter. But I saw as I got out of detention that, I wasn't going to allow that injustice to happen to anybody. That's how I got into human rights work and Kenya Human Rights Commission, Kituo Cha Sheria. Because I also didn't want the system to think that they had traumatized me sufficiently to do anything. So a lot of human rights work, even within the law, you find that somebody is mobilized around a particular ideal, a particular position they have and they hold dear. Maybe a woman who was raped and says that should never happen to anybody. That's the end of it, and they get involved. So yes, when I see young people, the Gen Z rising up and all that in anger, I can internalize it. I can, relate, to it. It's only that the Constitution was about making sure that they were safe, and they were not, killed, they were not disappeared, and so forth. And I think that can still happen if you get a leadership that believes in the Constitution and its implementation. But the other thing is, any Gen Z alumni, when you see what is happening and that anger, there is comfort, because as you age, you start wondering, am I going to die and leave this shit still on? When will there be change? And so you see what I call links and continuities. You look back and you realize, this is what I did, and it's still continuing. It's continuing. People are resisting oppression, and they are demanding, their rights, and that's the soul of the nation. Actually, it's a good place to be in, although we are losing people, but maybe that's a price we have to pay for liberation. Yeah, that's what happened to Kimathi, the Mau Maus, and people like JM, whose 50th anniversary is being celebrated on the 2nd of March, because he was assassinated. His body was found on the 2nd of March, 75. Yeah. And there was serious demonstrations in the university, actually, by students.
Yeah.
Because of that. Yeah.
But what would be your comment on bodies like IPOA?
That's a great question, because in the Constitution, which institution is left standing now? In my view, it's just the judiciary. The judiciary is the one that is keeping us from the fascism of the executive. All right. The others have been knocked down, whether it's IEBC, whether it's IPOA, because the institutions are not strong. Even the judiciary is not strong as an institution. It's that you have judges and magistrates who are courageous and want to follow the law. But I know there are quite a number who are intimidated, quite a number who are, corrupt. So for institution to be strong, in my view, and this is relating it to the judiciary, they should look at their differences, because in the judiciary can be its worst enemy. There are gender divisions, ethnic, religious, generational, and even region. Yes, and ideological. All right. So you can find people, pursuing a very good project, but it's opposed from within, which allows the politicians. The politicians are geniuses in dividing people. They will use the cracks, to get some people. This is what we are going to do. A good example is the lack of dialogue between the superior courts. That I mean the High Court, Court of Appeal, and the Supreme Court. You see, if the superior court, that is the Supreme Court, has the attitude that is infallible because it's supreme, that's a problem, because no court is infallible. And when you find the High Court deciding on one issue and it's confirmed by the Court of Appeal, the Supreme Court should be very cautious in overturning that consensus. Okay? And that's it's called judicial politics. You discuss it in the academy, and basically say, we need to have a position on demonstrations. We need to have a position on rights and so forth and so forth. Because you see, if the Supreme Court is seen to be the graveyard of jurisprudence, the politicians are happy. They will say, tutangojea huku, mahakama ya juu. So those divisions, and we talk to the judicial a lot about it, because they should, as an institution, they should know that they are under siege, and they should look for public support, because they are waded into African judicial systems. So there are a lot of elders who support them, and I think they need to, to operate as an outfit, because the judiciary has, as you know, there's a JSC, the Chief Justice, the head of the judiciary, but she is also the president of the Supreme Court. Okay, she is the chair of the National Council for the Administration of Justice, which actually brings in the three arms, where discussions can happen about tensions and so forth, and how to make the administration of justice seamless. Because you see, if you are dealing with corruption and the investigators are taking bribes, that prosecution will not succeed. Or where they do a good job, then the prosecutors do the opposite. Or where investigators and prosecutors do a good job and then the judge is corrupt. So what I was saying is that there is what I might call collective leadership in the judiciary. Okay, all those, you have heard of the Kenya Magistrates and Judges Association, it has a leader. Kenya Women Judges Association, it has a leader. Kenya Judicial Staff Association, which has the majority of people. They have, also a president. There's something called now the Justice Judicial Leadership Team, I think it's called. we used to call it JLAC ourselves, where the Chief Justice, the Deputy Chief Justice, the President of the Court of Appeal, and the presiding judges of the other courts, that's High Court and Associate Courts, right? Come together, and there's somebody who is appointed from the Supreme Court, and there's a magistrate. They come to advise. It's because the worst that can happen is where a Chief Justice is seen to be a monarch, who can actually be shaken. But once you have that leadership coming together, that's the institutional leadership. So that the Chief Justice is not just seen to be alone. And we tried that, and in some cases it worked. It works. It works when you are as Chief Justice and you are making a point and everybody is behind you. All those people, you feel, strengthened. Because the people who rule this country, you don't want to meet them without witnesses. Yeah, the narrative changes before you even get back to your chambers.
Yeah.
So the office of the Chief Justice is, apart from being legal and constitutional, is also very political. You need to know who you are dealing with, and what message do you give to presidents. See, it's in my case, all the time I told the presidents, prime ministers, deputy presidents, that the judiciary has to be independent. Because if it's not, the enemies will capture it and they will come after you. Mm-hmm. So when it happened to Uhuru, I tried to call him, I didn't get it. Just to tell him we had this discussion that the judiciary is the only place you run to. Your kids have run there over issues of license. But the nature of things is that the judiciary has been an appendage of the executive from colonial period. There was a time when the judiciary was a department in AG's office. Yeah, and that history is still there. Yeah. When you talk to presidents, I think it's Ruto who came to the judiciary and he is saying, that he got a mandate from 5 million people. And so he doesn't understand how the judiciary can subvert that, that
it was Uhuru.
Yeah. So yeah. So but the constitution, which they all swear to protect, gives the judiciary, some jurisdiction. And if they think the finance bill is not right, they're going to declare it. Yeah. And that's how it should be. So they find the constitution very, very inconvenient.
Yeah.
And I think that's where, the tension comes from. And the independence and the integrity of the judiciary in any democracy depends on the constitution, those who have constitutions. But those who don't have constitutions, of course, they have common law and whatever. But above all, the vibrancy of the people themselves. Because if people don't become the supporters of a judiciary that is opposed to abductions, okay? When the judiciary rules on demonstrations that they should happen, rules on the issue of majority party in parliament, the other one on the Haiti, when the judiciary said no, the police are not supposed to go for those missions and so forth. If the people don't rise up to support the judiciary, when the judiciary issues a contempt of court order against the IPG. Why can't we as citizens arrest him? You arrest him because we have those constitutional rights.
Yeah.
Yeah, instead of demonstration, we go and capture him, we abduct him, take him to the court. It's citizens arrest.
Yeah.
You know? So the actual thing about the vibrance of people's support is very critical. But that's a problem also because politics is politics of division. There's still issues of ethnicity. Uh, and so people start saying, this is our government. How can we, And that can also be reflected in the ideas of judges and, judicial officers. So fundamentally, what we're talking about is actually the politics. The politics fundamentally is the politics, because if you have a political leadership that obeys court orders, there's no problem. Yeah.
I think I have follow-up questions.
Yeah.
For that.
Yeah.
One, I will take you back to the 90s.
Yeah.
You were charged for contempt of court.
Yes.
Now we have seen what is happening around Ahmed Nasir and his law firm. I just want to speak specifically just to the law firm.
Yes.
And how the Supreme Court has conducted itself in that matter.
Mm.
Now, when you compare to how your trial was and what is happening now, are you seeing any stark differences, or is it history repeating itself?
It could be both. First of all, I have problems with contempt proceedings. I think under the new constitution, whether there is the contempt jurisprudence and so forth, is unconstitutional. Because how you see any common law doctrine or any statute has to be aligned to the constitution, right? Because the constitution is a supreme law, and that's what article, I think, is 20 says very clearly. If it's not aligned, you develop it. Okay. So contempt under the 2010 constitution is problematic because judges have delegated sovereign power. So when Ahmed Nasir and others go to those courts are not what judges used to say, my court. These are people's courts. Because the people themselves have given you the power as a judge, to hear them and settle disputes. So for me, the Supreme Court should have thought through this. There is the issue of due process. There is the right to fair hearing, etc. They're all in the Constitution. So I've always thought that in that matter, they shouldn't have adjourned that matter. The Grand Mullah, my friend, would have come in and they say, look, you keep on saying that we are corrupt. You talk about jury pesa, and so forth and so forth. Do you still think that we'll give you justice? Okay? And if he says no, then you tell him, then we are going to hear you on the following conditions. First, you go and file a petition before the JSC and Article 168 to ask the JSC to remove us. Yeah. So that is, we're all in the Constitution. You're saying, instead of scandalizing us and saying this and the other, if you have the evidence, take it. Evidence of corruption. I know now he's taken evidence of gross misconduct, so that is still sub judice. But I also found odd that the apex court would ban people working in its chambers, and that people holding brief for the farm, will not be allowed to be heard. So it's Article 1, 2, all those articles basically show that that can be done because you're subverting that delegated sovereign power by saying individuals, can be heard. And that's how I think about contempt. Contempt is very arbitrary, there's a story that Professor Okoth Ogendo used to tell us about one Luo person who went to court in some court in Nyanza, and he gets to court. The court is in session, and he tells everybody who was seated there, Yaore, which is a greeting in the Luo, I think, because they should have responded, Yaira. So the magistrate gets very, who is that? Who but in the process, the magistrate commits him, locks him out for contempt of court. And as he's being pushed out, he looks back and says, what kind of a court is this that doesn't allow people to greet others? So there is history. If there is the sovereign power that they are enjoying is delegated to them by us, it means the other power, because sovereign power stays with us, it means there are two parallel centers of power, and the one of the citizen is more powerful, and so you cannot say a citizen, I won't hear you, or, and then start talking about contempt. The contempt, I think the LSK should challenge it in a petition to find out whether it is constitutional, because its origins are common law, and they could be feudal, for example, where the law was the court was presided over by a law lord, and is the owner of the land. These people court serfs work under him and so forth. It's a different ballgame. And the UK doesn't have a constitution like the one we have, so that has to be interrogated. But the main thing was he wasn't given a hearing. Yeah.
I have a question on
Yeah.
that line. Huh?
Yeah.
So I think I was reading somewhere, you now have almost 1,000 complaints against members of the bench sitting in the JSC.
Yeah. No, I don't think that's the figure. I asked for I have them somewhere. I got them from from the SRG, the chief registrar, because I wanted to have the data. First, there is a data that shows very clearly that between 2010 and 2024, there are only 12 applications that went to the president to set up a tribunal. Only 12. Staggering, stunning data, because that comes to one petition that was succeeded, in a year, those years. And I remember they have figures of which ones have been heard, and obviously dismissed. There are some. I had 7 petitions for removal. One was from Law Society, a guy called Nyongeza, I think, in Mombasa. And he said that I was behind moving the Court of Appeal from Mombasa to Malindi. Okay, that wasn't my decision. So you get some that are frivolous, and of course the JSC has lawyers, and it has the power to basically say, we can't take it to the president. It's frivolous, and vexatious. I think the other one, there was one I faced of Kinyanjui, a lawyer called Kinyanjui, who filed, I think it was a petition here saying that since I said I'm a man of all faiths, the oath I took using the Quran wasn't binding. Okay, so the judicial and that those petitions are very boring because you've got to respond to them. And the JSC was very particular during my time in making sure that they were responded to, and if there was a recommendation that you ask the president to set up a tribunal, we did that with Nancy Baraza. It was fast. Within a month, it had gone to the to the tribunal. But so there are others that are, from what I saw, people also confuse the disciplinary proceedings against magistrates because those figures are lumped up together.
Yeah, so
Okay.
I think that's where I was.
Yes.
And that's why I said members of the bench
Yeah.
in general.
In bench,
And
yes.
and the reason I was asking that was, does it show that we do not have faith in the judiciary, or
That's us. We are 50 million, and it's you're talking of what? 1,000? It shouldn't worry you, because I think my position would be the Judicial Service Commission cannot sit on those complaints. Okay, because although we don't want to say they are guilty or whatever, in my view, when you have one corrupt magistrate, one corrupt judge, that person not only brings dishonor to himself or herself, but to the system of rule of law, and also the institution itself. It could be only one person, and the others are okay. But it's so critical what you're saying, that it should be processed very quickly, so that within a time frame, reasonable time frame, this person is either cleared, or if he's a judge, there's a tribunal set up for it, and so forth. So that's the valid, as well as what is called judicial laziness. People who go to court 10 days in a month, or they delay judgments for God knows how long. Okay? Those are things that make the judiciary its own worst enemy, because you don't want to do that. People will think you are delaying because you have been promised a bribe or whatever. So it has to sort itself out. And I think that in judiciary there is a culture of you have heard that my friend Kyoko, right? Mutua, sorry.
Yes.
Yeah. What? Mutuku, yes. Oh, God.
Don't worry.
I have somebody called Mutua Kyoko.
Oh.
Yeah, we say ni uzee na uzembe. So, when you are in the judiciary, there are these perceptions, where, yes, Mutuku was saying he's taking bribes, he's doing this and the other, There are perceptions, but perceptions are worse than reality. So it's up to the judiciary as an institution, to come to you and say, what is this we are hearing? Because it's like a family, isn't it? If your family has a thief, and people in the village are saying, you brother, family of thieves, you call the guy and say, what you're giving the family a bad name.
Yes.
And we might even have our houses burned, by the villagers and whatnot. It's the same metaphor for the judiciary. Okay. I said when I was in the judiciary before I left, when I filed my my declaration of wealth or declaration of poverty, whatever it was. And I went through I called the Auditor General to do the forensic lifestyle audit. All right. I thought that is one way the judiciary could deal with it. Because you see, as the law stands now, if you go and ask for information about the declarations of wealth, apparently that act says that the judge or the judicial officer has to consent, which is unconstitutional. Yeah, because it's freedom of information 35 allows the citizen, and this is a citizen who has given that judge delegated sovereign power. So I think that the judiciary has to deal with these issues. One of the ways is to say we'll subject them to forensic lifestyle audit or make the declarations public. Okay? You've seen cases where people are being interviewed and they can't say how they acquired a particular property. At that point, that is a clear case of the JSC instituting removal proceedings. At that point, you don't have to, or suo moto, they can do it. So there is a stuff that even the Law Society can take up, because the judiciary should never have that perception, of corruption. They should be known to be a judiciary where nobody can ever think of taking a bribe. And that's of course is very difficult. It can't happen overnight, but it's a journey that they have to start. Yeah.
Let me just take you to your tenure as the Chief Justice. What do you think are some of the notable things that you want to be remembered for at your tenure at the judiciary? And also, what are some of the things that you think you didn't get it right?
My position has always been in Kenya, you should never talk about your legacy. Okay? Yeah. Because your legacy is also judged within the lens of politics of division. Okay? A lot of people that I have talked to, those who are angry with the 2013, presidential petition, first think that I'm the one who decided alone. We were 6. Secondly, they rightly say that they call the judgment a quickie, which is which is and so I've dealt with that issue myself in my memoir, explaining what was happening, within the 14 days. The fact that suo moto we wanted the auditing to go on, it wasn't finished, and we had to decide. So it was unanimous, and the mistakes that were identified, we took the decisions to the university so that they can debate it. And they critiqued it as academics and the legal profession should do, particularly a decision that is hurried up. It's 14 days. So, and that is the background of even Maraga's decision 2017. The universities and other people said you have to look at these things and so forth. And through the Judicial Training Institute, they internalize them. Okay? So for me, that's why I don't go into legacies, because I think the question of that, particular petition, basically think that if the scrutiny had happened, we would have found stealing of votes from both parties. And in my mind, what I was thinking is that once that is done, I would invoke the law of equity, which is in Article 10. If you come to the, yes, and those guys, their hands are never clean. You see others bribing people. And the judges can take judicial notice of, of that kind of thing. But the most important reflection I have, on petitions, presidential petitions and other petitions, is that they will destroy the judiciary. Okay, in the sense that they bring to the institution the divisions that are in the body politic, and so the presidential petition. I've always said that even if you brought Solomon to listen to hear that case, he will be driven out of town. Yeah, and I write in my memoir about going to Kasarani on the 9th of April 2013 to swear in Ruto and Uhuru, and the uproar, when I was announced I've come, what the natives, they basically the acceptance was loud, and I said, these are Jubilee people. Of course, what do you expect? They think I did that for them. And I was wondering that if I went to Kambani or Nyanza, where code, whether I wouldn't be stoned. So basically, there's that aspect, and I get very concerned that people judge me on that petition. They don't look at. I mean, personally, the only thing I say, I always look at a contribution that I made in the judiciary was to urge the Supreme Court over 3 years to come with a theory of interpreting the Constitution. Okay, and I decided with dissent, like the gender rule. Okay, and then in others I will write, concurring opinions and so forth. And after 3 years, we go to the digital migration case. Okay, and we gave that theory. Said this is how the Constitution has to be interpreted, and so forth and so forth. And it has taken root in some cases where we combine the Constitution, the provisions, the preamble, Article 1, 2, you can go to 10, you can go to the one on which is in the Bill of Rights, then 159, and then the other, the actual provision is 259. Okay, then you go to Section 3 of the Supreme Court Act, which basically says that we are not legal-centric. We have to look at the history, theology, etc. So that's something I tracked, and I'm always happy that it happened, because I think our constitution should marry the common law jurisprudence that we got, whether it's holistic interpretation, harmonization, and so forth, and then bring it into the constitutional, interpretation. And I think the other thing that people don't focus on was the stuff we did on at the level of administration of the institution itself, recruiting judges, and this was a recruitment on the basis of gender, the face of Kenya, the youth, and so we were very, very deliberate. And we set up the Judicial Training Institute, which I thought was the institution of higher learning, that we could go there and decide on, judicial politics, of deciding and so forth. And it was also important in terms of having conversation, with the other arms of government, because all the magistrates and judges will be there. So it's not one, a discussion between one and in terms of, I guess, terms and conditions of service. With the help of CRC, we were able to, as much as possible, to alleviate the stuck hierarchical, systems. That when I got there, my salary was almost a million shillings before taxation. That's the gross, right? And there were still people earning 5,000 shillings in the judiciary. So that's what we had to, to deal with the salaries and the remuneration commission. There was this great woman called Sarah Serem who helped us, kind of equalize that. I don't know. I still think that my position on how the judiciary should be addressed and dressed is something that I think I succeeded in. I wrote a paper and we discussed it in a colloquium, and it was accepted. But later, you know what happened. Now it seems that it's the lawyers who like wigs. They should read my paper and see how I track the issue of dressing and addressing from the feudal period. This idea where we say, "My Lord, my prayer this morning is," that language is feudal. Okay, and then of course the scarlet marindas and the wigs, very feudal also. Yeah, the African sun. And the constitution, making, whatever, the CKRC, people said that judges should not wear wigs and robes. They should come with indigenous robes. It's there in the, and when they were asked why, they said, during the Mau Mau, people who sentenced people to death wore scarlet robes and the wigs. So I think basically the other thing, of course, which is rarely, it's known by Muslims, because we were able to extend the Qadi courts from 14 to 57, and also mainstream the Qadi courts. They were not part of the judiciary, so it's like they were an offshoot. So a Qadi then comes in as a resident magistrate, and then they go on to be senior magistrate, principal, whatever, the chief magistrate. And the chief Qadi himself starts at, I think, the chief magistrate. Yeah. So there were these reforms I was happy with. But I'm just flagging them because there are a lot of people who would say, that's...
You're forgetting technology.
Yeah, technology,
and
of course.
especially because after you left and COVID came afterwards, and I think it went a long way in ensuring
It was the build-up of that.
Yes, and the judiciary has become... our vision was Pillar 4, you remember, the judiciary transformation framework. As technology as an enabler of justice. And the initial thing was very, very interesting because the outsiders like us, we came to the judiciary with the laptops. So we were okay. But I know some colleagues, I don't want to mention at the Supreme Court, who, although we gave them laptops, they never used them. They wasted a lot of reams of paper.
Writing.
Yes. And I wonder, as you grow older, you get arthritis. Why would you want to? So technology, and then it's leapfrogged
Yeah.
As you say, during COVID. And now you can hear counsel, from the comfort of your home.
Yeah.
Which I think is good. I liked the when the Chief Justice Comey said that habeas corpus, the courts were open for 24/7, and you could file it online, and there will be a judge on duty to hear it. So it's so good. But this country, the politics is that people just see the negative.
Yeah.
There's a history. There's during my period, the development of judiciary jurisprudence was in the in the High Court, because they are the ones who are getting the applications and so forth. In fact, at that point, I used to think that the Court of Appeal was a graveyard of progressive jurisprudence. But now it has been taken by those great judges there in the Supreme Court. So I don't know where the graveyard is now.
we all know where it is, we just can't say.
So, but it's seesaws, it's twists and turns. And I think if they keep to the theory that we developed, they won't be a problem. Yeah.
Previously, you've given an interview, and I could be wrong. If I'm wrong, just correct me. And you've said that Kenya has truly never been a nation. It has been a cluster of communities here trying to create a republic, or a nation.
Yeah.
Do you still stand by those assertions?
Yeah, I think when you look at the preamble, there's a commitment there where we say we're conscious of our ethnic and whatever cultural and religious diversity, but we want to live together in unity as a sovereign nation. That's a vision of it. And I was basically saying we have to implement that vision. That's why you see even the issue of devolution. Political power is being shared between the counties and the national government, and there is equalization of resources and so forth. That's how you build the nation. When you go to Article 91, all these political parties are unconstitutional if anybody goes to court to challenge them, because they organize on a basis of what? Hate speech, militia. They don't even call congresses. If you ask them who their members are, they won't show you. Okay? They are very lucky that the registrar of political parties has never read the constitution. They will move there and ask ODM or Wiper, who are your members? Okay? Give us the accounts. Where is your account? And where are the contributions and stuff? Because it's very important for parties to have members, because paying fees to a party is a commitment to its ideology and politics. So that's basically, I look at the constitution as having a vision for building this sovereign nation, and we have to look at what is holding us back. Okay, if we go to chapter 12, we realize is public debt, is corruption, is wastage of resources, which we see every day, and the people being very happy with the culture of stealing. Like a fellow member of the Law Society, giving details of how much his watch costs, his belt. It's actually very. I don't know what to think of it, because I've interacted with rich people in this country and out of this country who you won't know. Okay, in America you find a very rich person. It's just wearing jeans like everybody else. It's when they call you and say, "Oh, I'm going to the Caribbean. Do you want to come?" And you find he's got a yacht or a jet.
Yeah.
So I don't know why these guys spend time, if they get rich, talking about belts and shoes and socks. I'm sure yeah, we even get laughed at by Nigerians. You remember once Orengo said that his suit was worth $5,000, and some lawyers in Nigeria said, $5,000? We start at 25. So I think the project of a sovereign nation is still with us. And I always say your generation, Gen Z and millennials, is a generation that will bring that vision, dream about, because when the Gen Z said they were tribalists, everybody was happy because we know what that means in terms of politics, what that means in terms of marriages. There will be multi-ethnic and so forth, and the country will start reflecting its sovereign, nationality. And if the devolution works, Kitui, Makueni, Mandela, Wajir, and so forth, the resources start going to the marginalized communities, then you feel you belong, to a nation. And that's where I was basically coming from and saying that it's about the culture, it's about that unity, is about that, making sure where the Constitution gives us those sites that we should, implement. Yeah.
What are your thoughts on the small claims courts? I'm assuming they were started to maybe.
No,
the
thinking I think was during us, but I think they were set up. Is Maraga who set them up, and then Kome?
Yeah.
I to be quite honest, I haven't studied them, and I haven't asked people how they operate. I have been more incited and excited about the African justice system. Okay, which for me, I've always thought that when you have a country that has 10% of its people not coming to the justice system, and they go to elders and whatever, that formal, that's the one I call formal because the majority go there. There should be an integration of it, and that is happening. I think it's going to be very empowering of elders if they sit like the Meru ones, Jurijeke, they sit, in Meru, they make a decision, and that decision is filed in one of the magistrates' courts there, So those elders will feel that they have judicial power, and that's how, I think that's how it should be. The small claims court, I think it was basically based on monetary jurisdiction, isn't it?
Yeah.
So that it's supposed to speed
up things.
Oh, okay. It's a good idea, so that you don't congest the, I guess, courts which are dealing with millions and whatever, and then it can be quicker. Actually, I was involved in one small claims court. I was an executor and administrator of a will, and I got the papers, and there was some dispute, and it was handled very quickly. Maybe because I was a party, I don't know. Yeah.
So let me ask you.
Yeah.
Critics have always opined that you did a lot of delegation during your tenure. Yes.
Yeah, that's true. Because I've already told you about the collective leadership.
Yes.
In the, in the judiciary. And what you don't want to be is to be the one making all the decisions. First of all, constitutionally, the CJ is not the accounting and administrative head of the judiciary. So that's the CRJ. So you have to be very careful. You stay out of administration and accountabilities, financial. And you give that person as much support as you can. There was also the issue of auditors. Apparently, the auditors we had in the judiciary when I got there were from Treasury. And I thought this was unconstitutional. They shouldn't be there because there is an auditor general under the Constitution who audits all of us. So I talked to the guy called Ouko, who was the auditor general, and he told me they shouldn't be there. I audit the judiciary and the executive. So I called those guys to the office and they said I should get permission from the CES Treasury to allow them to come and see me. So the activists in me, I went and changed the locks. And that's how we got them out of the judiciary. So there was, that, and I had actually in the office of the judiciary, a guy called Wanyama was an auditor who reported to me directly if he saw there were things that, because he was still the head of judiciary, so you were also accountable. So that's, part of the delegation. Then we built the office of the CJ. When I got there, the office of the CJ had 2 secretaries and 8 bodyguards. There was no other capacity. So we ended up getting the chief of staff, the chief legal counsel, the guy doing the communications, and then we formed the judicial ops person, the office of judicial ops person, so that it was very difficult for somebody to say I was making all the decisions because they were. And that delegation, the wisdom of it is that it's the institution that is, it's also helps you not to be lumped in some stuff that, like what Cholet did, for example. That was our case. You can imagine if I had anything to do with it, I would have also been charged. So delegated authority is the hallmark of collective leadership. Okay, if you want to have that space to operate, then these are the leaders of Court of Appeal, presiding judges and so forth. They count because that is their institution. The institution is not the CJ's institution, and that's what informed us. And when I say us, it's from the day I got into the judiciary. I particularly after we employed in 2012 28 judges, that cycle of collective leadership broadened so that you could see, you could feel